The Juneau World Affairs Council and the University of Alaska Southeast, in collaboration with 360 North, present the 2018 World Affairs Forum, Europe, Allies and Alliances in a Turbulent World. In this session, Making America Normal Again, with a little help from Europe, we hear from Willamette University's Professor James Nafziger. How can the U.S., working with our European allies, get back on track to ensure fulfillment of our international obligations? And perhaps more importantly, to restart suspended initiatives and consider new ones to improve international legal cooperation in various sectors, including trade, the environment, defense, migration, and the Middle East imbroglio. Bottom line, the U.S. and Europe need each other.
All right. So Professor Nafziger is a Harvard-trained attorney. He's the secretary of the American Society of International Law and the vice chair of the International Law Association, which is headquartered in London. That's in Europe. And then he's also professional ties institutions to China, Mongolia, not in Europe, and also the Trinity College of Dublin and the University of Barcelona in Europe. So he's visited Juneau back in 2007, so you may want to illuminate us a little bit about that. The glacier was a little bit closer here. So welcome. Thank you.
Thanks very much, Peter. Well, I'm really delighted to be back here. This is actually my fourth time in Juneau. I had always wanted to visit Alaska, and I almost made it when I was in the Army, and we had some choice in our assignments, and actually I drew Alaska. And I thought, great, it would have been Fort Richardson and Anchorage, a city I've yet to see. I never get past Juneau. But with all of my worldly possessions on the way up there, they changed my orders to Germany, which wasn't too bad. And it was the Vietnam War period, so I was definitely glad to avoid Asia at that point. But I hadn't gotten to Alaska yet. But I, right after my Army career, a couple of years, I went to law school, and I had the wonderful opportunity one summer during my law school days to clerk for the Faulkner Banfield law firm here, which I understand still has about the same name, but not the same personnel. And I just had an absolutely wonderful experience, fell in love with Juneau, and so ever since, I've really had a particular place in my heart for the city. When I started teaching, the very first student that I got to know in some way right off the bat was Bruce Botello. Imagine my luck. And I was asked to judge, right off the bat, judge a moot court competition where Bruce performed, and I thought, boy, I was just bowled over. If he's typical, this is going to be a good run at Willamette. Well, he certainly had a good run here as mayor a couple of times. I think I'm right. He was the longest ever attorney general in Alaska history. And I know Bruce has been a prime mover in the World Affairs Council, and sorry that he couldn't be here, but his wife Lupita teaches, and this is spring break, so they're away. I'll get to see him Sunday morning before I leave. I certainly take pride in that relationship, which resulted in my next two visits to Juneau, thanks to Bruce, and this one really on the initiative of student much more recently, Heather Parker, who is on the board of the World Affairs Council, and she claims that she has an appointment with the governor at this hour, so she is not in the audience. But I really am glad to have had the opportunity to teach those students, as well as to maintain, with respect to Bruce, to maintain a strictly nonpartisan posture here, to have taught two courses in which your senior senator, Lisa Murkowski, was enrolled. So finally, along the way in my junior experience, I even discovered a second cousin, Heidi Gerson, who is in the audience today, and that really was a wonderful addition to my Juneau connection. So there you have it. That's my Alaska background. Well, I certainly am grateful to Professor Jacoby for having set the stage in his very informative, insightful talk, especially with its focus on norms that Germany is committed to. And I gather there was more of that last night. I couldn't arrive because of various flight problems until towards the end of the Q&A, so I didn't have the benefit of this presentation. I hope I won't overlap too much. But let me begin my substantive remarks this afternoon by quoting a rather extravagant view of America's place in the world as follows: "We shall run the world's business whether the world likes it or not." No, the source of that observation is not the person you may be thinking of these days. Instead, it was a Mr. Holroyd speaking as an American mining tycoon in Joseph Conrad's novel, Nostromo. He went on to say that the air of the new world seems favorable to the art of declamation. That's a word you don't hear very much these days, and I think maybe the current version is public tweeting, but I'm not sure of the connection there. This is fiction, but Holroyd's bluster certainly has a jarring ring of immediacy these days. During the last year and a quarter, President Trump has pulled the United States out of the Trans-Pacific Partnership, in whose formation we had been instrumental, vowed to scrap NAFTA, imposed a travel ban on refugees, immigrants, foreign visitors from specific countries, all three of these actions in the first week of his office. And he later went on to give notice of terminating our obligations under the Paris Climate Accord, threatened war with North Korea, repudiated the Iran nuclear deal, recognized Jerusalem as Israel's capital, and imposed stiff tariffs on imports of steel and aluminum. I wrote all of that even before the Wednesday announcement about the tariffs on Chinese goods, which is a very different kind of framework, and we'll get to that a bit later on. I hasten to add that what you certainly know, and that is that several of these declamations, as I'm now going to call them, were later reversed, modified, or suspended, thanks to the diminishing number of so-called adults in the White House, the advisors that Professor Jacoby made reference to. One declamation to withdraw from the Paris Climate Accord cannot take effect until November 4th, 2020, ironically, or perhaps intriguingly, one day after the next presidential election. Anyway, trying to track developments, as I particularly did in preparation for this afternoon, has been a little like looking through a kaleidoscope with constant new patterns and new kinds of chips in the kaleidoscope. I thought of that this morning, in fact, when I heard the president more or less reverse a position that he seemed to be taking yesterday, which had to do with the the $300 billion budget, where I guess many of us thought he might actually refuse to sign that, but he, of course, changed his mind. And I thought of that also when it was announced that John Bolton really was going to replace McMaster. I had simply dismissed the possibility that there had been rumors that Bolton would become our next national security advisor. So there's a lot of development, if not chaos. What seems clear, however, is that our conduct of foreign affairs has become unusually unsettled, not to mention unsettling. Full compliance with norms has become abnormal. I make my living, as I think Berger brought out, teaching and writing about international law and collaborating with others in its development. So what concerns me today is not only that we have gotten off the track of compliance with our international obligations and of cooperation and new initiatives, but also that America is losing its capacity for progressive leadership, a source of whatever greatness we can claim. American exceptionalism is certainly nothing new, but as it grows, as it seems to be today, so does our reputation for unreliability. What excites me particularly about the theme of this conference is that our allies and our other friends in Europe, despite their own political problems these days, can help us get back and remain on track if we work together. I have to note that I will not be including Russia in my definition of Europe. It's a different Europe, and I will not really make much reference to those Eastern European countries that are currently in the grip of anti-democratic regimes. In making America normal again, with a little help from Europe, I want to focus on norms in three senses of the word, namely established practices, mainstream or predictable standards of behavior, and binding rules of international law and governance. I'd like to avoid all partisan politics and polemics, but criticism about our current administration in Washington, I think, is inescapable. Despite American exceptionalism, Europe can help realign our international posture in at least four ways, a couple of which can be combined. One is by reminding us of creditable and mutually beneficial models of cooperation. Second, related, by demonstrating the benefits to us of a transatlantic partnership even today. Third, by agreeing to significant measures of compromise in our mutual interest. And fourth, by putting meaningful pressure on the United States to comply with our obligations. In the time allotted, let me focus on 5 topics that necessarily engage the United States with Europe: NATO, the nuclear agreement or deal with Iran, the President's recognition of Jerusalem as the capital of Israel, with plans for relocation of our embassy there, immigration and refugee matters, and international trade. I think a lot of what I'll say you already know, and probably has been covered last night and certainly in Professor Jacoby's presentation. But I want to make sure everybody's on the same page, so I will simply take you through some of the basics about those topics. As background for all 5 of these topics, let me make 5 observations. First, public opinion polls consistently show that a majority of Americans favor a close working relationship with our European allies and other partners, I should say, to secure shared interests through common action and rules. Secondly, we need these partners strategically, as we've seen, at least to a limited extent, in the Middle East, Central Asia, and the Korean Peninsula even. Thirdly, what might seem to be purely domestic initiatives can have transatlantic effects. For example, if our tax code is deployed to aggressively snatch investment and corporate headquarters from other countries, the incentives for a race to the bottom, such as by manipulating tax treaties and thereby evading sensible taxation, will harm us all. Fourth, a reputation for integrity and reliability on one hand and truculence on the other shape the conduct of foreign relations and eventually affect all of us. And finally, fifth, however imperfect they may be, well-established international institutions and organizations such as the UN, its specialized agencies, the G20, the EU, NATO, the WTO, NAFTA, and others help us all in the long run. We gain nothing by withdrawing in protest from organizations such as we're doing now in UNESCO, as we learned in the past when we withdrew in earlier point in time from UNESCO as well as the International Labor Organization. I thought we had learned our lesson, maybe not. Let me cite just two positive examples from the last few years in terms of what can be gained in work with international organizations. The G20, with its substantial European membership, has been instrumental in reining in two of the most pernicious beggar thy neighbor policies, namely tax havens and currency manipulations, despite the guardrails put in place by the International Monetary Fund in terms of monetary matters. Also, another institution, the Organization of Economic Cooperation and Development, the OECD, has been on the vanguard effort to combat governmental and corporate corruption. Both of these organizations are still animated very substantially by North American European cooperation. Okay, so topic number one is NATO. During the 2016 presidential campaign, Donald Trump called NATO obsolete. As president, in a speech at NATO headquarters in Brussels, he initially declined to acknowledge Article 5 of the NATO treaty, which is the core of collective defense, the provision that an attack against one country is to be regarded as an attack by all, and all will thereby become involved in the collective defense. Ironically, NATO has implemented Article 5 only once, and that was, anybody remember? This is my audience participation moment. 9/11. That's it. You got it. I don't have to take you through that. To his credit, the president later backtracked from his skepticism about this traditional bulwark of collective defense. Also to his credit, the president has repeatedly insisted on compliance by our European allies of their commitment several years ago to devote 2% of their GDP to the mutual defense. Professor Jacoby spent some time on that. I have no idea whether 2% is the right amount or not, whether it was well to go down from 3% or perhaps we should be at 1%. But it is an obligation. It is at least a very strong pledge from our allied partners to devote 2% of their GDP to the mutual defense. Only 5 countries have done that at this point. The United States, which is considerably out in front with something like 3.58%. Correct me if I'm off a little bit on that, but we're certainly far out in front, and it is disconcerting to me that we now, especially after what I heard this morning from the president, will have an even more bloated defense budget than we've had. In any event, the other countries besides the United States are the UK, Greece, Poland, and Estonia. Although several of our allies either are close to full compliance or have pledged to reach the 2% level in a timely manner, or are committed to simply improving their national defense capabilities and training and equipment. I think a couple of the Scandinavian countries fall in that category. Unfortunately, two of our closest allies have a particularly long ways to go. Germany, currently at 1.2%, our figures are the same on that, and Canada at less than 1%. Canada is really the biggest renegade in this effort to comply with the obligation of 2%. To me, it's essential, having established that, that we all share more of the burden, particularly defending Europe, so that the United States can focus more broadly on the main threats. For example, European allies should build most of the military power to deter Russia, so that the United States can better concentrate its resources to sustain command of the global commons, the sea, the air, and space. And that way, maybe, over time, even reduce our bloated defense budget. So we do need a little help from Europe. The United States, on its part, has responded much, I think, to President Trump's credit by continuing our strong commitment to the European Reassurance Initiative. The ERI, which the United States established in 2014 after the Russian intervention in Crimea, has paid for expanded defenses against cyber warfare consistent with the Tallinn Manual, which is kind of a Bible on cyber warfare. Tallinn, of course, being the capital of Estonia, and knowing of Estonia's sophistication in dealing with the Russians, that's not a big surprise. But in any event, part of the payment for this effort has come from the ERI. It's increased U.S. support for exercises in Eastern Europe, improved sale and outright gifts of equipment to Ukraine, and new stockpiles of equipment in Europe adequate to equip an entire U.S. Army armor division in case of emergency. So far, the cost of ERI has not been negligible. It's $10 billion. That is, since the initial effort in response to the Russian intervention in Crimea. Okay, well, let's turn next to the Joint Comprehensive Plan of Action of 2015, otherwise known as the Iran nuclear deal, by which the 5 permanent members of the UN Security Council, Germany, the European Union, and Iran agreed to a regime by which Iran committed itself to limit the scope and content of its nuclear program over several years in exchange for relief from various nuclear-related sanctions imposed by the other signatories. As I think most of you know, but again, just to make sure everybody's on the same page, implementing legislation requires the president every 90 days to certify that Iran is in compliance with the deal. The parties to it rely on scientifically and technologically based assessments by the International Atomic Energy Agency in Vienna. The IAEA has consistently attested to Iran's compliance. Despite this definitive evidence, however, President Trump has left U.S. commitment to the treaty in somewhat of a zombie state. He has not yet withdrawn the United States from the treaty or reintroduced sanctions against Iran, although he has endorsed new sanctions, arguably not directly related to the treaty itself, to the nuclear treaty. He has, however, twice refused to recertify Iranian compliance with the treaty, and on January 12th, he declared that quoting him, the disastrous flaws in the nuclear deal with Iran, if they're not fixed within 120 days, which is a deadline coming soon, he would pull America out of it. The president specifically issued an ultimatum for a new agreement that would end the expiration clauses that, for example, allow Iran, after 15 years, to enrich uranium beyond the 3 2/3% normally required for commercial power production, a ban on ballistic missile testing by Iran, and unconstrained access for the International Atomic Energy Agency inspectors to any military site, regardless of whether there's been any indication of nuclear activity there. I hope you know the irony in that, that it would be a matter of seeking to extend the IAEA's competence while rejecting its findings. The Iran deal is, however, the result of hard-fought trade-offs. It was a long time in the making. The chances that it can be substantially renegotiated are slim indeed. Opening it up in the hopes that America can expand it to force Iran to limit its regional ambitions is almost certain to fail. Meanwhile, the agreement unfortunately hangs by a thread. If the United States unilaterally withdraws from it and reimposes sanctions against Iran, one reason I was not only startled but rather depressed by the announcement of John Bolton's appointment. In any event, if we do that, we would clearly breach our obligations, and Iran, if it chose to do so, could reinstate its otherwise taboo nuclear development. But of course, one would hope that the other parties to the agreement would remain and would forestall any possibility of Iran simply reinstating its suspect nuclear development. So where does European allies really fit into this unsettling situation? The president has made it clear that he expects America's European allies to help him get what he wants. As he put it, if other nations fail to act during this time, I will terminate our deal with Iran. Both the French and the British, eager to cooperate as much as possible, say they too are keen to discuss follow-up agreements with Iran about missile development and regional interference, but they maintain that any such talks should be open-ended and not linked to the agreement itself, which is apparently achieving exactly what it set out to do, at least based upon the evidence provided by the IAEA. In my view, Europe should steadfastly remain firm about this commitment and this refusal to take account of other, some of them very reasonable grievances we have with the regime in Tehran. They should also be much more vocal in correlating compliance by parties to the agreement with the IAEA's evidence. Finally, they should make clear that if the U.S. abandons the agreement and restores sanctions against Iran, they will honor their own obligations, increase investment if they see fit in Iran, and trade with it, and generally fill a vacuum of whatever economic opportunity the U.S. has left behind. Of course, going beyond the agreement, the United States and Europe should together put all pressure possible on Iran to relax its consistently defiant posture towards Israel. That, of course, is much easier said than done. All right, let's turn to let's turn to that area and look at the issue of Jerusalem. The President's decision to recognize Jerusalem as capital of Israel and to relocate our embassy there is, of course, a symbolic gesture for the most part, but it violates international law. That is because Israel is the one country, the one territory, I should say, in the world where other states are not at liberty to select Jerusalem as their capital. It doesn't matter if, for example, the United States decides to relocate our embassy in Vancouver from Ottawa. It doesn't matter if we seek to relocate our embassy in Mexico from Mexico City to Puerto Vallarta, maybe for reasons beneficial to our diplomats, but in any event, you can't do that under international law in Israel. Ever since the United Nations Resolution 181 in 1947, during that chaotic period of in the aftermath of the British withdrawal from Palestine, the city of Jerusalem has been established as an international entity governed, of course, variously by Israel, and until after the 6 Days War in 1967, Jordan. There have been numerous Security Council resolutions of the UN ever since then that have reiterated that status of Jerusalem as a matter of international law, with its roots, of course, in history going back hundreds of years. In fairness to the President, his action tracked a congressional resolution in 2003 purporting to establish Jerusalem as Israel's capital among, I think, 4 provisions altogether dealing with relationships in Israel. But that legislative venture by our Congress was contested by both Presidents Bush and Obama as an unconstitutional infringement of the executive power over the conduct of foreign relations. The Supreme Court later agreed in a fascinating case involving this, sort of tangentially but importantly, the status of Jerusalem, in effect upholding our traditional acceptance of Jerusalem as an international city. Had to do with what gets stamped in the passport of a American child, American baby, born in Jerusalem. Anyway, leaving that aside, there's a consistent line of authority that we simply have violated international law by that symbolic gesture. And of course, we're the only country in the world that has done that. We are alone. So again, what should Europe do? Well, there's not much Europe can do in this instance, but it could symbolically respond by simply refusing to conduct diplomacy with the United States on the site itself in Jerusalem. Of course, the United States and its allies need to be in close touch on many matters in that part of the world, but the symbolic part of it would be for Europe simply to deny discourse about it on site in Jerusalem. Next up is the topic of immigration, generally a shared problem across the Atlantic, but specifically somewhat differentiated as between the two sides of the Atlantic. Europe's refugee crisis 2 years ago threatened the fabric of the EU. It posed a dilemma of having to reconcile historically humanitarian approaches with cultural and economic considerations. Of course, it was an extremely difficult period for Merkel in particular in Germany. I think most of you recall that experience resulting from a kind of open arms to the refugees in Germany that led to a great deal of domestic political turbulence, as well as issues with other countries in allocating refugees among the countries on a principle of solidarity. Eventually, the European Court of Justice dismissed a challenge by Hungary and Slovakia to a detailed regime of allocation, but unfortunately those two countries have yet to comply with the decision in terms of cooperation in the allocation of refugees. And in any event, the worst as far as the flows into Europe seem to be over as a result of the agreement worked out with Turkey. The Dublin principle of first arrival, first responsibility also came under fire, this time quite understandably, of the Mediterranean countries of first arrival. This is not to mention the costly and logistically complicated problems of temporary resettlement, welfare, and efforts to try to assimilate the refugees into the working environment and otherwise in the new host countries. Meanwhile, the U.S. has addressed a very different range of issues related to migration. In the name of combating terrorism, President Trump imposed bans on the admission of refugees, immigrants, and foreign visitors in different ways from designated countries, most of them predominantly Muslim. In a sort of judicial game of whack-a-mole, the courts have responded by striking down each of the president's repeated efforts to rescue the ban with modifications and with new language. As is not so well known, the president also lowered the total annual cap on refugee admissions to 45,000, which is the lowest level in 32 years. Come down from fairly dramatically from about 80,000, 85,000, and that had come down from higher levels 8 or 10 years ago. Also, on the advice of his assistant Stephen Miller, he recharacterized refugee admissions for the first time in our history as a security issue. The recurring hysteria about undocumented persons has also loomed large, even though the estimated number of illegal border crossers has dropped by one estimate 82% since its peak in 2000. That's a little misleading because the number has been creeping upward again. But in any event, it's quite a dramatic drop in the last 18 years. Of course, we know about the controversial issue of expanding the wall at an estimated cost of $18 billion, the last I saw, and of course the continued expectation by the president that that tab will be picked up somehow by the Mexican government. That looms large and of course is caught up in the effort to try to stabilize the status of the children under the DACA program, no longer children for the most part, under the DACA program. Taken together, questions related to refugees, undocumented persons, and foreign citizens in this country eligible for temporary residence under the DACA program require our attention untainted by the nasty racism and fear-mongering that unfortunately has troubled our national conversation about these issues. Moreover, a few of the administration's measures have violated our international obligations under the United Nations Covenant on Civil and Political Rights, the International Convention on the Elimination of All Forms of Racial Discrimination, and the 1981 Protocol to the Refugee Convention, the basic agreement on refugee matters going back to the end of to the situation of displaced persons in Europe after the Second World War. Let me give you just a few examples. Discrimination based on national origin is taboo, even though from the time of the Chinese Exclusion Act in this country in the 19th century until 1965, our immigration law did give effect to such discrimination. But neither federal law nor binding international human rights law any longer permits that kind of discrimination. Secondly, mass expulsion of primarily Salvadorians and Haitians enjoying temporary protected status in this country might raise, remains to be seen, especially on an individual case basis, might raise questions of what goes by a French term, non-refoulement, which is embedded in the Refugee Convention, that therefore under the 1981 protocol is binding on the United States, and it simply prohibits return of anyone, even on temporary protected status, in our case, to a situation where their life is endangered. And certainly there has been enough of a response so far from Salvadorian community in particular that indeed would be the case in individual circumstances, even though the basis for the temporary protected status had to do with conditions of volcanic eruption and so on, unrelated to the particular jeopardy that individuals may now face if they are returned. So those are just a couple of examples of how we really need to be very careful about our way we proceed in order to remain in compliance with our international obligations. Despite their own troublesome problems of immigration and refugees, our European friends can help us by demonstrating the benefits of their traditional elevation of human rights realities above security anxieties, as its institutions, including its courts, have normally done, even in these troubled times in Europe. As well as specifically, they can demonstrate the folly of allowing an abstract notion of national security to, shall we say, trump human rights in individual cases. Finally, I want to turn to this very recently developed problem of international trade. President Trump's hostility towards international governance of trade, normally based on principles of classical economics and comparative advantage, near and dear, as the whole idea of free trade is, to the members, the majority at least, the members of his own political party, that hostility is problematic. His mercantilist view that in accumulating national wealth, exporting is winning and importing is losing, underlies his conviction that all bilateral trade with each and every country must balance out to be fair. Recently, as a protest against international regulation of trade, the administration has attempted to cripple the authority of the World Trade Organization in Geneva by blocking the appointment of new judges to sit on the World Trade Organization's vital 7-member appellate body, thereby handicapping a fundamental process of dispute resolution that ironically has upheld U.S. laws and practices in the past. That's on hold, just as so many appointments, of course, in the administration itself in Washington have been on hold for too long a period of time. Better known, of course, has been the president's determination to either demolish NAFTA or demand radical changes in it. Most everyone agrees that after a quarter century, reasonable modifications of the agreement are in order. We've learned a lot. It's not a perfect agreement. We know that there ought to be a review of any agreement that important after a period of years. These sort of concerns really have focused particularly on NAFTA's rules of origin that define the source of products to make sure that the source is sufficiently from within the three countries that are parties to NAFTA to enjoy the favorable free trade among the three countries. The current rules specify specifically as to car and car parts, which are a major question in terms of rules of origin. The current rules specify that at least 62.5% of a car must come from within the North American region, excluding costs such as marketing and shipping. The Trump administration wants three major changes: a higher regional content requirement of 85%, a new requirement of 50% American content, and a vast expansion of the so-called tracing list of parts, such as brakes, axles, and tires. Most economists agree that these requirements, certainly if all three of them were to be adopted, would play havoc with established supply chains. As you know, negotiations have been going on. The last I heard in Mexico City, I think they're still taking place down there with very little probability that our two partners in NAFTA will subscribe to the major changes that the Trump administration has proposed. Well, that's better known than perhaps the blocking of the judges on the WTO, but best known of President Trump's trade-related initiatives, of course, has been his order under Section 232 of the Trade Expansion Act of 1962, our basic trade law, to impose a tariff of 25% on steel imports and 10% on aluminum. It's highly controversial for several reasons. First, because it's unusual in its reliance on a national security exception to our normal commitment to relatively free trade, consistent with the General Agreement on Tariffs and Trade, GATT, within the WTO framework. The President's order is also controversial because of its probable impact on downstream users of steel and the price of their products for the consumer. There are an estimated 140,000 workers in the steel industry whose jobs are apt to be better protected by the tariff. But there are 6.5 million downstream workers and countless consumers like you and me, whose interests are potentially threatened by the imposition of those tariffs. Moreover, as we all know, the new tariffs could easily spark a retaliatory trade war. President Trump famously quipped that trade wars are good and easily won, but that is certainly more doubtful than not. The President's action followed a nearly year-long study, which disappointingly resulted in a report of fewer than 60 pages plus annexes that takes little account of broad criticism during the year in the annexed testimony. Why now? Well, the various theories having to do with the congressional race in Pennsylvania, having to do with the concurrent negotiations in Mexico City as a kind of ultimatum to Canada and Mexico. Who knows? But those are a couple of the explanations of why this is now being or has recently been announced. Why the national security rationale? Ordinarily, other provisions of GATT and our federal law allowing for the imposition of duties against dumping of products in the territory of another country at less than fair market value, or in response to governmental subsidies of exports, or in response to demonstrably unfair trade practices, or in response to infringements of intellectual property rights by manufacturers of exports, or in response to economic emergencies, serve as the basis for imposition of tariffs, which in any event, in most of those instances will require very substantial review within the Commerce Department. And of course, there was a review in the Commerce Department about the steel and aluminum imports, but also in the International Trade Commission. Much more careful consideration of the pros and cons of imposing a tariff, even if any of those conditions I enumerated are present. As a result, incidentally, we have more than 150 additional tariffs beyond the uniform schedule of tariffs on the books today that result from initiatives to respond to any of those conditions I mentioned. I haven't really gotten very far into the most recent and perhaps the most serious threat of a trade war based on the very recent announcement concerning Chinese imports. That seems to have been more creditably based upon unfair trade practices and in response to infringements of intellectual property rights, because I think we all know that China has been slow at best to respond to some of these problems that have certainly affected our interests. But again, I just haven't had a chance to study that in any detail, nor has there been a very clear communication from Washington about the basis for the measures directed at China. In any event, Section 232, the national security provision, allowing for imports, import tariffs, for that reason, not only completely bypass the process that I mentioned, but also manage to avoid what is called, most of you probably know about this concept, most favored nation treatment, which is not only a long standing commitment by the United States according to our own law, but also a very basic provision of the General Agreement on Tariffs and Trade and our whole participation in the World Trade Organization, according to which any particular favorable treatment in terms of duties, in terms of import tariffs and so on, extended to even just one country, has to be extended to all. And that would be, of course, all members of the WTO, with exceptions, and I'll come to that in just a moment. But in any event, that's a partial explanation, perhaps, for the recourse that the administration has taken to Section 232 as a way of avoiding the complications of that requirement. The President, of course, has justified Section 232 treatment in view of what everybody agrees is the global problem of excessive steelmaking capacity generated primarily by China that has been driving the global price of steel down to a level that arguably threatens the entire steel industry in this country. That much is clear. It must remain competitive in the face of lowered steel prices globally. But for one thing, the Chinese are not among the major exporters of steel to the United States. They rank 11th, and their share of U.S. steel imports has declined dramatically in recent years. So to make that clear, they certainly are a basis for this problem of excessive capacity that's resulted in export of steel to some extent to the United States, but also around the world in such a way as to drive down the price to a level that is a threat to the steel industry. Of course, we know that over the hill, Canada is the biggest exporter by far of steel to this country. It has a lot to do with the importance of the automotive industry, of car parts and so on. In any event, European allies such as Germany and Italy are also players in the import market, thereby calling into question a national security threat based on critical shortages of steel and aluminum in the event of military needs. The validity of the import measures is questionable under international law for at least 3 reasons. One is really more of a principle, but it's a bedrock principle of international law, and that is good faith, that you interpret the international obligations in good faith. National security is simply not the same as a national interest, which I think we can all agree needs to be a very core concept of our foreign policy. But national security isn't the same thing, and not well known is that the Supreme Court some years ago did interpret Section 232, even though it has been invoked so seldom because of the threats that it presents of trade wars and so on. The Supreme Court held exactly as I stated, that national security is to be reserved for real emergencies, that is not the same as the national interest. And my view is, we can talk about this in the Q&A, my view is that we simply haven't proceeded in good faith by invoking that national security provision. Secondly, discriminatory exemptions beyond free trade areas, such as NAFTA and some, I think it's 21 other countries, under bilateral agreements, are certainly available. And this would include, of course, NAFTA in terms of being a free trade area that would be exempt from what otherwise would be discriminatory treatment in favor of certain countries and against the interests of competing steel or aluminum exporters to this country. There's just been a little announcement today, I think in the President's message, in fact, that we're on the verge of essentially confirming a bilateral agreement with South Korea that again would fall within this category of exemptions to what otherwise would be discriminatory treatment. But you cannot discriminate on the basis of a state-by-state selection. And thirdly, there's a requirement that the tariffs on imports must be product-specific, such as steel wire, even if all products are generically raw steel. Whether we're talking about steel ingots or steel wire, they all have to be justified as a matter of national security, or as a matter of anti-dumping, as a matter of countervailing duties against export subsidies by foreign governments, whatever. It has to be product-specific, and it hasn't been reduced to that yet. So again, where does Europe fit in? The European Union could respond with retaliatory tariffs or it could simply cooperate to forestall an all-out trade war, despite our own apparent unwillingness to work with our European partners so far to address this problem, or the problem now of the Chinese imports and exports. And then more fundamentally in terms of steel, this core problem of excessive steel making capacity. I do have a set of quotations that I think I'll skip. And these quotations are from the United Kingdom Steel Manufacturers Association, ThyssenKrupp Steel in Germany, Eurofair, which is representative of the European steel industry, our own National Foreign Trade Council. All of these very specific statements were made in the course of testimony this past year pursuant to the initiative taken to study the problem of steel and aluminum import tariffs, and or simply of imports. And in all instances, they make clear not only that the best way to proceed is cooperatively, the best way to perceive is to work together on some of these problems. They all seem to suggest that we haven't really exhausted that approach. And in a fascinating statement by ThyssenKrupp Steel in Germany, we're reminded of our own U.S. Supreme Court decision some years ago that national security under Section 232 must be interpreted more narrowly than simply the national interest. So I've come to exactly to the end of an hour, which I was allotted, and so I will skip a more elaborate conclusion, simply to say that bullying doesn't work, norms do work, so does cooperation. Europe and the United States need each other more than ever. Thank you very much.
Questions? Take a moment to ponder.
So your title was Making America Normal Again, and yet I did not hear anything that you said that leads us towards normal. I mean, you gave a few things at the end of saying, well, you could do this, but you gave no examples of anything being done by the present administration that would lead us to that.
That's right. Well, of course, I did limit my remarks to first of all, to international relationships. I did limit my remarks to the theme of this conference on European allies. I did make clear that I was speaking of three types of norms, one of which is near and dear to my profession, to my income, namely international law, such that what I am saying is that there are various trade-offs among these 5 topics, and I indicated as I went along some places where Europe could give in, places where Europe could put more pressure on this government, some places where we simply ought to be cooperating and collaborating and working together as much as possible. Perhaps that's all overly optimistic given the current situation in Washington and the problems that European countries are having. But I think that in making America normal again, limited to our commitment to norms in the 3 senses, again focused heavily on Europe, that the Europeans and the United States can really benefit each other by working together, and the Europeans need to give in. I gave the example right off of the pledge or commitment to 2% of gross domestic product for defense. I regard that as an obligation. I regard that as an example of where the Europeans can do more, where they can compromise, and they can relieve us of our extended commitment in Europe. They can take over to a great extent with a greater commitment of their own. On the other hand, there is certainly plenty of room for the United States in the interests of not only our alliances, but our larger global interests to work with the Europeans to try to keep the, for example, the Iran nuclear deal in place.
Who initiates the enforcement of international law? And when you identify that person or body, how likely is it that that person or body be outside the control of the United States president or independent of it, for example, the court system, something like that? But who initiates the enforcement of international law?
To some extent, our own institutions seek to enforce our international obligation. What's good for the goose is good for the gander. It operates on the basis of reciprocity, that what we do we can expect will be done elsewhere. But you're right, it has to go well beyond our capacity, our willingness, our ability to simply enforce international obligations ourselves. And I speak not just in terms of trying to improve our participation in international cooperation. I speak also in terms of the capacity of foreign interests to pursue claims in our courts and to pursue lobbying activity, to pursue diplomacy and so on, to try to make sure that we remain committed to those obligations. But I don't have to remind anyone, I don't think, that the international system is very decentralized. Of course, there is no single court. There is a world court. There are various arbitration groups with specialized functions. There are important specialized agencies like the WTO and so on that do have enforcement mechanisms, and that should be well staffed with judges in the appellate body, for example, that we've blocked. But these are examples of institutions that do and can in the future play a role in enforcing international obligations. But a lot, of course, is left up to diplomacy, is left up to attempts to simply entice our friends abroad to work with us in solving some of the problems we have between us and some of the mutual problems we have in the world as a whole. I don't think it's going very well at the moment, but call me optimistic. In any event, I think it's worth trying in an effort to try to re-normalize our posture in international relations and in the world as a whole. So it's a complicated answer to your question, but yes, there are ways within the country to enforce those obligations, and there are institutions abroad for doing that, but ultimately we have to rely very heavily in this decentralized system on the whole process of give and take diplomacy and so on.
I think we have time for one more.
Hi, I want to raise a question about the reliability, if you like, of U.S. commitments in the context of the treaty versus executive agreements. Obviously, treaties are binding on all administrations. Executive agreements, in some people's opinion, and since you mentioned John Bolton, in his opinion in particular, they're binding only on the administration that signs them. Bolton was instrumental, for example, in convincing George W. Bush to pull out of the agreed framework with North Korea, which allowed North Korea then to proceed with its nuclear program when that agreement was dropped. And he claimed that Bush could do this because it was signed by Bill Clinton and therefore was not in any way binding on George Bush. And I think he made the same agreement or the same argument again with respect to the P5+1 agreement with Iran, that again, it was signed by Barack Obama, but that has no obligation whatsoever in his argument for the current administration, for the Trump administration. So the problem is we can't get 67 votes for anything to ratify a treaty anymore. it seems.
Well-
It's virtually impossible to get 67 members of the U.S. Senate to agree about anything. And if executive agreements, do not have any binding characteristic, and we create that impression, my basic question is, why should anyone trust the United States to do anything that it agrees to? How can we, in any sense, create a sense of continuity in our foreign policy if, in fact, every agreement we sign can be rejected by the next administration?
Yeah, well, it's a very good question. Something like 95% of all of our agreements are executive agreements, and a lot of them have to do with status of forces of U.S. forces in other countries, wheat deals, and a lot of things that, for good reason, probably should bypass the Senate in its constitutional role of advising consent by a 2/3 vote. NAFTA, by the way, is another good example of an executive agreement that President Clinton was instrumental in seeing through. Yes, these are more easily attacked, but they do have a force of their own. They do, in fact, when you get into questions of which prevails, a treaty or a subsequent contradictory law, we have canons of constructions on later in time, whatever, to resolve that. Same goes for executive agreements. Same goes for a basic process to justify our withdrawal from an agreement. Even though it's quite true, it doesn't have the solid foundation of Senate advise and consent and the process of ratification by the United States in that context. But executive agreements aren't to be taken lightly in a constitutional sense. There have been many, many cases in our constitutional law experience that have confirmed the significance of executive agreements. It's quite true that, and I gave a couple of examples of how relatively easy it is for the president to withdraw from agreements, but it isn't without some substantial constraints on the president's doing so.
We'll reconvene at 4. Thank you.
Thank you.
That was Willamette University's Professor James Nafziger discussing Making America Normal Again with a little help from Europe. The Juneau World Affairs Council and the University of Alaska Southeast, in collaboration with 360 North, presented the 2018 World Affairs Forum, Europe, Allies and Alliances in a Turbulent World, with support from AEL&P, Kerr Alaska Kensington Mine, DreamHost.com, Haight and Associates, Sea Alaska, the Prospector Hotel, and Wastman and Associates.